Are there odds less than zero? Because that's the odds that federal judge Alvin Hellerstein is going to allow Donald Trump to take his state court conviction on 34 felony counts of business record fraud, election interference, the Stormy Daniels thing, take it over to federal court and then have a federal judge toss the conviction in a trash can along with the sentencing as if the judge was some sort of giant etch-a-sketch. The chances of that happening, zero. Based on a hearing that Judge Hellerstein held earlier this week. I'm going to cover it here on the MeidasTouch Network and on Legal AF. What's this all about, Popok? This is about the Stormy Daniels hush money cover-up election interference trial. That's a mouthful. Remember the one that Michael Cohen testified at? Yeah, that one. Donald Trump convicted 34 felony counts by a 12-0 jury of his peers in New York, beyond a reasonable doubt. And then, after conviction, of which 99.9% of the facts that were put on in front of the jury involved Donald Trump's actions before he was even president in order to interfere with the election against and the campaign against Hillary Clinton, okay? He then, after the conviction, but before the sentencing, boom, the United States Supreme Court, July 3 years ago, came out with the quote-unquote immunity decision, which gave Donald Trump, and I guess future presidents, but really Donald Trump, immunity that he can't be prosecuted and no evidence used about what he does as president as long as it's part of his official duties, his core constitutional functions, and isn't a part of his just private conduct or behavior. Well, Stormy Daniels, the $130,000 payment, the arrangement of the conspiracy, the payoff so she wouldn't go to the press about her having sex outside Donald Trump's marriage, all of that happened before Donald Trump was president. So how could it be presidential conduct subject to the immunity? But it confused a lot of people. And so after that came out, the argument for the Trump administration was, the state court judge should do something about it. He should throw out the conviction. He shouldn't do any sentencing. But there's a big problem. They didn't run to federal court immediately and argue to a federal judge like Judge Hellerstein, hey, we get to take the case to federal court because there's a statute that provides that a federal officer who under the color of their federal office does something and has a federal defense, they can take it to state court. They can take it to federal court. But Donald Trump waited 4 months after the July decision to go back to federal court and say, hey, federal officer, federal defense, I want to go to federal court. Why? Because he wants a federal judge to toss the conviction and the sentencing based on the immunity decision. Again, the immunity decision is about things that happen while you're in office. The only thing that happened while Donald Trump was in office, the conspiracy was completed. It was just the payment, the payment back to Michael Cohen and certain public statements that Donald Trump wanted to make to continue the conspiracy happened while he was president. But just because he talked to Hope Hicks, the press secretary, doesn't mean that converted his conversation into presidential communication or that she was being the presidential press secretary when he's trying to cover up for the scandal. And that's their argument. So we had a big hearing in front of Judge Hellerstein, 92 years old, sharp as a tack, by the way. I'd vote for him for president at any time. Fresh off of an earlier hearing the same day involving the arraignment of Maduro. Remember the guy that was captured along with the oil fields of Venezuela by your and my taxpayer dollars and U.S. military? Same judge. So he sets a briefing schedule. The argument for Donald Trump's lawyers is that, and the Second Circuit Court of Appeals wants to hear Judge Hellerstein's view on this, is that what do you do with the immunity decision? It came out between the conviction and the sentencing. Does it have any impact on the decision of Judge Hellerstein to deny, because he already denied 2 years ago, the attempt by Donald Trump to take the case, the state case, to federal court? The judge reasoned then, wait a minute, I'll put it simply. A private affair, literally, is not presidential conduct. So no, you don't get over the first hurdle because in order to bring a case into federal court under federal removal, you've got to show federal officer conduct, colorable conduct, part of your job description, And then you have a federal defense. He says, this is not federal officer conduct, but having sex with Stormy Daniels, an exotic dancer. And maybe for Donald Trump, it's official conduct. And then on the defense, you don't have a defense that's federal. Election law, that's not a defense to the criminal case that you just got convicted of. And the judge tossed it. Then we go into the world of the sentencing. Immunity decision comes out. And the judge says in the hearing, in open court, you're too late. And the lawyers for Donald Trump says, what do you mean? He says, you're too late. You waited, first of all, the conviction already happened. The sentencing already happened. You didn't run into court and try to get back to me with a new notice of removal. It's called a notice of removal. They said, well, Judge, we're prudent litigants, the lawyer for Donald Trump said. We wanted to wait and work it through in the state court proceeding before we came to federal court. He said, no. Now you're trying to get two bites of the apple. You're waiting to see what Judge Merchan in the state court's going to do. And when you didn't like that ruling, right, then you came to me. Too late. You waited 4 months after the immunity decision. If you thought you had a legitimate good faith argument to take this case post-conviction, post-sentencing to federal court for a second shot with me, you would have done it immediately after the immunity. It's a 1-page, 1-paragraph document. Why didn't you file it? Oh, well, Judge, we made the strategic decision. He says, right, you made the strategic decision to stay in state court and make your arguments to the state court judge. And you're late, meaning you're out of time, either through laches or foot dragging. You waited too long to bring your removal, to bring this case to federal court. I said, well, Judge, you have to analyze the immunity decision and its impact or implications and how it maps on to these issues. The Second Circuit, your boss has told you that. He goes, yeah, I will. First of all, you're late. On that alone, no more, there's no removal here. And then he went on to, this is a very hot back and forth, between the judge and the lawyers for Donald Trump. Very little from the Manhattan District Attorney, by the way, because he didn't want to snatch defeat from the jaws of victory. That's when you sit down. I've been an advocate before, like I'm about to get up and I realize the judge is on my side and I sit back down. It's hard, because you're paid to talk and you've been doing that your whole life as an advocate, but you sit down. Discretion is the better part of valor. So Manhattan DA did a lot of sitting down. Whereas on their feet, bouncing around, lawyers for Donald Trump. And they said, Judge, you got to apply the immunity decision. He said, I will. You will. And again, nothing about the immunity decision and its format for dividing the world into personal conduct, official conduct, and core presidential conduct. What they said is for core presidential conduct, there is absolute immunity and you can't use evidence related to core constitutional conduct or official conduct stretched to its outer boundaries in a case against a president. Okay? So what the judge said is there's no core constitutional conduct here. Talking to your press secretary in order to lie to the American people about the cover-up of your conspiracy is not core presidential function. Even if I take your the president's powers, official conduct, stretched to its outer boundaries, which is what the Supreme Court requires him to do, still, this falls outside of that and falls into the last bucket, which is personal conduct. And personal private conduct has no immunity. That's how that immunity decision divided the world. And they said, but Judge, he talked to Hope Hicks, the press secretary. He met with Michael Cohen in the White House in order to write the check back to him. And he said, that may be, but that did not convert the underlying conspiracy for which he was convicted into core presidential function or official conduct of the president. Therefore, there's no federal conduct, federal officer conduct that's even colorable that gives you a ticket into the federal courthouse. You got to stay in state. Now, why do they want to move from state to federal? For those that are confused, let me try to clear that up. For Donald Trump, it's a two-step process. He tries to get the case over to federal court on removal. He then argues to Judge Hellerstein, that the conviction and the sentencing should be vacated based on the immunity decision. Let's just play this out. Hellerstein says no. They take it to the Second Circuit Court of Appeals. Second Circuit Court of Appeals says, no, not happening. They then take it up to the United States Supreme Court on an emergency application or some sort of application to see if the court is interested in ruling on this. So it shortens the appellate track for Donald Trump. If he stays in state court, which is where he's at, then he's got to go up through the First Department Appellate Division, which sits over trial courts in Manhattan. I'm a member of that court. And then if they lose there, which is likely, they'll go up to the Court of Appeals, the highest court in New York. And failing that, they then have to try to jump the track and go to the United States Supreme Court. So this shortens the path they're trying to get to the Supremes. I just don't see them getting through Judge Hellerstein. As soon as we get the order, I'll report on it. But based on those that were in the room and reporting that I know about, I would fall out of this chair dumbfounded if Judge Hellerstein ruled in favor of Donald Trump and allowed this case to come over. They'll take it up on appeal, but he's not going to allow it. And he's been upheld in this case by the Court of Appeals a number of times. We'll continue to follow it. You're on MeidasTouch and Legal AF. Take a moment, hit the free subscribe button, come over to Legal AF YouTube, do the exact same thing, and help us with our Legal AF Substack, running a 35% off sale. Until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.